All right, everybody. The point of this video is to quickly give you a review of the 15 required Supreme Court cases from this year. Look, we know that maybe they're not as relevant this year on the sort of COVID version of the AP test because there's no multiple choice. There's no Supreme Court comparison FRQ, but you could use them as your second piece of evidence, possibly on your argumentative FRQ, and it could possibly be worked into the concept application FRQ as well. All right, so we're going to go through them real quick. We're going to go through them by theme, sort of like putting the similar court cases together. So let's do the two federalism cases first. The first federalism case is the way back one. This is McCulloch v. Maryland from 1819. It's really dealt with two issues. First, can the United States government create a bank if the word bank is not actually listed in the Constitution? And the part of the Constitution that is most relevant to this fight is the idea of the Commerce Clause. This is the part of the Constitution in which it says the government has the ability to regulate commerce, like economic stuff. And then the Necessary and Proper Clause, which says that the government has the ability to carry out any of the powers that actually are stated in the Constitution. And they can do anything that's necessary and proper to do that. So that's the part of the Constitution, the parts of the Constitution related to this question. You know that the Supreme Court did decide that the government can create a bank, even though it's not listed in the Constitution, because they said by using the Necessary and Proper Clause, they linked up the idea of a bank to something that's related to it, which is economic stuff, commerce, and that this was closely enough related, opening a bank or establishing a bank to commerce, that it's okay. It doesn't have to be specifically listed in the Constitution. And this obviously dramatically expands the power of the federal government to do lots of things not listed in the Constitution as you link it up to something like the Commerce Clause. It also deals with the question of, can the states tax the national government? The state of Maryland, where the first branch of the national bank was opened, was trying to kill the national bank because they looked at it as competition for state banks by like taxing the heck out of it. And the national government contended that the national government can tax the states, but the states can't tax the national government. And the part of the Constitution that's relevant to this is the Supremacy Clause, which says the national government is supreme to the states. And the Supreme Court ruled that the states cannot tax the national government because if you tax somebody, it indicates you're supreme. And we just mentioned the national government is supreme to the states. So the national government can tax the states can't tax the national government. All right. The other federalism case is really the opposite of the first part of the McCulloch case. This is the U.S. v. Lopez case. This was whether or not Congress passing what was known as the Gun-Free School Zone Act was like constitutionally within their power. This was a law that just gave enhanced penalties to anyone that was stopped carrying a gun within a certain sort of area around the school. This also deals with the Commerce Clause and the Necessary and Proper Clause because it doesn't specifically say anywhere in the Constitution that the government can pass something like the Gun-Free School Zone Act. But the government was trying to link it up again to commerce, saying that there was a connection between guns in a school zone and economic activity. This is an important case because the Supreme Court, in one of the rare times, said, like, no, like you can't do this. It's too much of a stretch to connect what you want to do, which is establishing gun-free school zones, to something that's in the Constitution, which is like commerce powers. So they struck this down, and it's one of the rare cases in which the government was told it couldn't use the Necessary and Proper Clause and link it something they wanted to do to the Commerce Clause. All right, on to the one case that we looked at in the executive branch unit, which is the Citizens United versus FEC. Federal Elections Commission. For me, this is one of the most influential Supreme Court cases in the last 50 years. This was the case that dealt with part of the McCain-Feingold Act, which established campaign finance reform rules that limited like what interest groups could do in terms of like spending their money on like election-related stuff. And this related to First Amendment, free speech, because how interest groups spent their money politically was considered to be like a free speech like type of issue. And the Supreme Court ruled that the part of the McCain-Feingold Act that restricted interest groups' independent spending was unconstitutional. So that essentially what this case established was that interest groups, which we now refer to as super PACs, these types of interest groups, as long as they spend independently of the candidates, meaning they're not talking to candidates, that they're just spending the money on their own to get somebody elected or to oppose somebody through commercials or ads or things like that, that they can spend unlimited sums. And obviously the impact of this case is that it has dramatically expanded the influence of interest groups to influence elections. All right. There are two cases involving Congress. Both of them are united by the fact they deal with how states draw congressional districts, and both of them involve the 14th Amendment, which we'll talk about in a second. So the Baker Carr case was the first one. This was from 1962, and this dealt with Tennessee's legislative districts and whether or not the way they were drawn was constitutional. The problem was that Tennessee was using outdated census information to essentially still draw their districts. So what was happening is areas over time had dramatically exploded in population, and other areas had declined. So you had essentially unequal legislative districts. So some districts had, like for example, one legislator, like one rep, but within that district you had 2 million people, and another district might have one rep and 10,000 people. So there were a group of people in the more populated districts that were arguing that they were being discriminated against, that their vote wasn't worth essentially as much as somebody that lived in a smaller district person wise or population wise. So this involves the 14th Amendment and the Equal Protection Clause. Anytime somebody feels like they're being discriminated against, it's 14th Amendment, Equal Protection Clause. And the Supreme Court decided that these districts were not constitutional. Because again, they agreed some votes were indeed worth more than others because of the size disparity. So this established the principle of essentially what we know is one person, one vote, and these legislative districts all essentially have to have approximately the same number of people in them now. And then the other sort of district case involves districts being drawn and race being taken into consideration. This is the more recent of the two cases. This is Shaw v. Reno in 1993. The question in this case, and again, it's a 14th Amendment issue, was whether or not the way North Carolina was drawing its congressional districts, whether that was constitutional. At dispute was really this crazy purple-shaped district here that goes almost the entire width of North Carolina. One of the issues North Carolina was having was that it had a pretty sizable African American population, but they were struggling to get African American congressmen elected. So one of the things they set out to do when they redrew their districts was to draw districts that we call majority minority districts, in which they were intentionally putting a minority group, African Americans in this case, into the majority within this congressional district. So this district was being drawn to sort of enhance the voting power of the African American minority group. They were being made the majority within this district. There was a coalition of white voters that sued, saying that this reliance on race was discriminatory against them. That's why it's a 14th Amendment Equal Protection Clause issue, and the Supreme Court agreed. Previously, the Supreme Court had ruled that race couldn't be taken into consideration to hurt the voting power of minority groups, and now they're kind of like even more narrowly focusing on it and saying that race can be the dominant factor taken into consideration, even if the intention is a good one to help the voting power of minority groups. So, race, as we talked about, even with affirmative action, can be a piece of the puzzle, but it can't be the predominant consideration when government is involved. All right. There's one case involving the judicial branch. This is obviously a big one. This is Marbury versus Madison of 1803. And again, we're not really necessarily going over the details of the case, but at the heart of this case was whether or not the Supreme Court could actually overturn a law passed by Congress, which was known as the Judiciary Act back then. Sort of relates to Article 3 in a way because there's nothing in Article 3 that says that the Supreme Court actually has the ability to strike down laws of Congress or actions of the president for being unconstitutional. But the Supreme Court in this case, it's a landmark case because it took that power for themselves and in the course of this case gave themselves judicial review. And obviously the Supreme Court has become a viable third branch ever since. You can imagine like what would the role of the Supreme Court be if they wouldn't have established the ability of judicial review in this case. And then there are massive cases that deal with civil rights. These are all amendments found within the Bill of Rights, obviously. Engel v. Vitale is in 1962. We'll do the religion cases first. This was the dispute over whether or not the New York public school system, which sort of required voluntary prayers to be said at the beginning of the school day, whether or not that was constitutional. They were meant to be non-denominational. They were voluntary. This clearly is a First Amendment issue because it involves freedom of religion. More specifically, it involves the Establishment Clause because the people that sued, saying that these prayers were unfair, were essentially saying that the prayers were a government attempt to establish or endorse a religion. Supreme Court agreed that these voluntary prayers were not constitutional because, again, just the act of the school sort of conducting the prayer was sort of an endorsement of prayer and religion. The other religion case involving the First Amendment that we talked about was the Wisconsin v. Yoder case. At the heart of this case is Wisconsin's law that requires all students in the state to go to school beyond or until the age of 16. There were a group of Amish families that were prosecuted and convicted for violating this Wisconsin law because the Amish in the state did not believe that their students should have to be forced to go to school beyond the eighth grade. They actually they believed that this endangered religiously their students to keep them in school longer than necessary. And they alleged that their First Amendment rights were being violated, and more specifically, the Free Exercise Clause, which deals with the religion, because the Amish were being prevented by the government, Wisconsin, from practicing the religion the way that they wanted to. And the Supreme Court basically said that Wisconsin's law was not constitutional, that it did violate these Amish students' rights. The Supreme Court basically ruled that Wisconsin wasn't able to prove that by making students go beyond the eighth grade until the age of 16 was going to sort of give society that much of a benefit that it was worth sort of infringing upon the religious rights of this Amish community. All right. Freedom of speech cases. You have Schenck v. U.S. This is the earlier one in 1919. This involved a man named Charles Schenck, who was convicted under the Espionage Act because he was essentially arguing, telling people that as World War I was going on and the government instituted a draft, they should not report when drafted. So he was arrested for essentially interfering with the government's war effort. This deals with the free speech part of the First Amendment, and the Supreme Court said that his conviction was constitutional, that speech can be regulated if it causes a clear and present danger to exist. We know the First Amendment's not like an absolute right, and one of the restrictions is if it creates a dangerous situation, speech is restricted. And that by him advocating people not go to the draft or through the draft when reported, it was creating a dangerous situation, and his actual conviction was upheld. So this limited free speech rights. The Tinker Des Moines case was in '69, a little bit later on. This involved free speech as well. This was the Iowa School District essentially suspending the two Tinker students on the right for the wearing of their black armbands meant to protest the Vietnam War. This is symbolic speech, but it's still speech, so it's a First Amendment free speech case. And the Supreme Court said that yes, the school district did violate their rights. This established a couple important things. Number one, first time the court really rules that students do not give up their constitutional rights when they go to school. However, they did leave the door open that schools could regulate student speech if it sort of created a violent situation or would disrupt the learning environment. But just that in this particular case, this Iowa school district wasn't able to prove that there was going to be a disruption or violence, so that the students' rights were indeed violated. The next case involves the First Amendment as well. This one deals more with freedom of the press. And the issue is whether or not the government could stop the New York Times from printing the Pentagon Papers. Remember, the Pentagon Papers were these classified documents from the government that were obtained by a man named Daniel Ellsberg, who was really disillusioned with the Vietnam War. And these Pentagon Papers had lots of info about sort of like the government strategy in Vietnam and what was really going on. And it contradicted like a lot of like what the government was actually telling the public. So Ellsberg leaked these documents to the press, and the New York Times was going to print, obviously, a portion of these papers, and it's going to make the government look bad. And the United States government tried to get the courts to prevent the New York Times from publishing the Pentagon Papers. And the Supreme Court said that no, they would not stop them from being printed. You couldn't stop somebody from saying something ahead of time. This is called prior restraint, when you stop somebody from printing something or saying something ahead of the fact. And that unless there are extreme circumstances, that this should not be tolerated, the idea of prior restraints. On to the Second Amendment. McDonald v. Chicago is a gun-related amendment. The question was, were Chicago's really strict handgun registration requirements, were they constitutional? These registration requirements were so strict that essentially this established almost a complete ban on handguns within the city of Chicago. This is obviously a Second Amendment issue, and the Supreme Court said that, like, no, these restrictions were not constitutional, and they established that individuals do have a right to own a gun. This is significant because it officially incorporates, it makes the states follow the Second Amendment and protect an individual's right to own a gun. DC v. Heller was heard 2 years earlier, which essentially overturned Washington, D.C.'s handgun ban. But because D.C. is not a city in an actual state, it's in a federal district, the verdict was not incorporated to all the other states. So this is the similar case that essentially incorporated the Second Amendment and gave individuals the right to own a gun in every state. Sixth Amendment gives like trial rights and the right to a lawyer. This case involves the man on the right, which his name is Clarence Gideon, who broke into a Florida pool hall and broke into a vending machine, stole some stuff out of it. He was accused and convicted. He was not given an attorney because Florida had a rule that you were only given an attorney in cases in Florida if the death penalty was an option, and clearly it wasn't in this particular case. So this deals with the Sixth Amendment and the right to an attorney. And the Supreme Court essentially ruled that Florida's refusal was not constitutional, that individuals in all types of felony cases, death penalty or not, are entitled to a lawyer. Another really significant infamous case is the 1973 Roe v. Wade case. That at the heart of it dealt with the woman on the right-hand side of the screen. Her name is Norma McCorvey, but she was known by sort of the pseudonym of Jane Roe in this particular case. She was prevented by Texas law from having an abortion procedure. This particular case does not necessarily deal with a specific amendment or a specific part of the Constitution because there's nothing in the Constitution that deals with abortion rights, which makes this sort of decision controversial in the eyes of some. However, the Supreme Court had previously talked about the fact that there was this penumbra that existed with rights, where the Supreme Court kind of gave off a vibe of guaranteeing certain rights without mentioning it by name. So one of those rights is privacy. It doesn't say the word privacy anywhere in the Constitution, but like there are amendments to deal with privacy. Like the First Amendment deals with like privacy with your religious and political beliefs. The Third Amendment prevents you from opening your home up to soldiers. The Fourth Amendment protects your private property from being searched and seized illegally. And then the 14th Amendment deals with things like equal protection and due process of law and those types of things. So it's kind of a blend of amendments that are involved with this. And the Supreme Court ruled that, yes, this Texas law forbidding abortions was indeed unconstitutional, that women do indeed have a right to matters with their own body. It's a matter of privacy. And if they wanted to undergo an abortion, they could. It did leave the door open, however, for some government regulation of the abortion process. Generally, this is broken down into the 3-trimester rule. In the first 3 months of a woman's pregnancy, the government really has minimal interference with the process. The second 3 months, months 4 through 6, the government can't ban abortions, but can regulate a little bit more regarding the process. And in the third trimester, months 7 through 9, there's much larger government involvement, including the ability of states to essentially ban abortions late term in a woman's pregnancy. And then there's one obviously very infamous civil rights case we talked about, which is the Brown v. Board of Education case. The date's wrong on this. It should say 1954. Sorry about that. And obviously this case dealt with whether or not the principle of separate but equal, which was established by Plessy v. Ferguson in 1896, whether its application in schools was like constitutional or unconstitutional. So this case dealt with schools in Kansas and whether or not segregation was legal. And the Supreme Court, obviously this involves equal protection clause, 14th Amendment, because it was alleged by the Brown family, Linda Brown over here, that by making her go to a segregated school, her equal protection rights are being violated. And the Supreme Court agreed that segregation was indeed unconstitutional and violated 14th Amendment rights. That obviously things were being kept separate, but they weren't equal, that white students were getting superior resources. But even in this particular case, which there wasn't for Linda Brown a dramatic difference in the quality of schools in her general area, that there was substantial psychological damage being done to African American students by separating them, that was establishing this notion of inferiority. And this obviously led this case to the integration of schools across the United States. All right, so look, that's a quick review of the 15 cases. Again, they may not be as significant this year as they normally are, but you never know when they're going to pop up.